First, let me go to the business context. Now, I've talked a little bit about Subchapter 5, the Small Business Reorganization Act, that is Subchapter 5 of Chapter 11. It applies to small businesses, and there's a debt ceiling there, and it also applies to individuals whose debts are primarily business debts. So in that situation, you can have a business that has too much debt to qualify for the Small Business Reorganization Act, but it's pretty close. So one thing a business might think about doing is paying down some of that debt so that on the petition date, it's below that debt ceiling. That can work, but there is a negative, and that goes back to this concept of preference. To understand what a preference is all about, it helps to have in mind the two big goals of bankruptcy law. The first goal is to give the debtor a fresh financial start. It has a laudable pedigree. It goes back to the Code of Hammurabi from the ancient or the First Babylonian Empire. It goes back to the Bible. There's bankruptcy in the Bible. The ancient Romans had a well-developed bankruptcy system. In our legal system, in the U.S. Constitution, bankruptcy is one of the enumerated powers of Congress. So it has a great pedigree. The other side of the equation is the creditors. And here we have to ensure that all creditors who are similarly situated are treated equally and fairly. Now, there are two ways in which debtors will sometimes violate this big goal. The first is they won't list all their creditors. That's a serious no-no. You don't list all your creditors, that's an imprisonable offense because you'll be swearing under penalty of perjury that you've listed all of the creditors. And that goes in the individual case and also the business case. The person signing the bankruptcy petition is saying, yes, we've listed all the business's creditors. So it is an imprisonable offense, but the good news is it'll be in a federal penitentiary as opposed to a state penitentiary. And I have been assured that the food is better in the federal penitentiaries. I've never actually been in a federal penitentiary or a state penitentiary. You do have to make sure you list all the creditors. The second way in which debtors will violate that big goal of treating similarly situated creditors the same is they'll make preferential payments to a given creditor in anticipation of bankruptcy. If you do that, that is called a preference or a preferential transfer, and after the bankruptcy is filed, the person in charge, whether it's the chapter trustee in, let's say, a Chapter 7, or the debtor in possession in a Chapter 11, has to go and undo that transfer and recover the asset for the benefit of all the creditors. Now, there is a question on look-back. Measured from the day we file the bankruptcy petition, if the creditor is an ordinary creditor, then the avoidance action to undo the preference can be done for any payments or transfers of assets to that creditor during the 90-day pre-petition period. And that is measured from the day the check cleared. If it's an insider creditor, then the avoidance goes back 1 year. And rather than getting mired in the details of what an insider creditor is, think of it heuristically like this. An insider creditor is a creditor who is either a family member or a close business associate, or if it's a business, a partner, a shareholder, or family members of those people. So you want to be very careful if you're starting to pay down debts to qualify for Subchapter 5, that you keep in mind those preferential transfer avoidance dates. Another thing that people will seek to do, this is especially in the context of individuals, take assets that are non-exempt. Take assets that are non-exempt and convert them to assets that are exempt. So, for example, you might say, I've got this wad of cash, I'll just stick it into retirement. Well, you have to be a little bit careful on that because the IRS has limits on how much you can contribute to a retirement plan within a calendar year. So you are going to have some real limitations on what you can do there. Or they might take all that money and pay down the mortgage. Well, you've got a problem there with the preference right off the bat. that you're paying down that mortgage because you're paying an antecedent debt, you're paying that creditor. That's a preference that would have to be avoided. So again, you'd have to keep in mind the preference avoidance time period. But those are some things that debtors can try to do. There are, of course, others, negotiating with creditors ahead of time. Now, the Bankruptcy Code has a limitation on being able to convince creditors to vote in favor of a plan. Once the plan has been crafted and you've submitted it to the court, you can't go campaigning to get the plan confirmed after a certain series of events have taken place. But suppose before you file the bankruptcy papers, you contact the creditors, you say, look, we've got all this debt. We're going to be filing a Chapter 11. We're going to propose a plan. What will work for you? How can we make a plan that will compensate you? We don't have the resources to pay you in full, but what will be your sweet spot that will encourage you to vote in favor of a plan that we propose? And if you don't have that many creditors, you can go sort of creditor by creditor and come up with what's sometimes referred to as a prepackaged Chapter 11, where when you file the Chapter 11, you already have the creditors on board. So it's not going to be nearly as complicated a case because you can, in essence, already have crafted a plan that the creditors are going to be willing to live with. So that's another thing that you can do in anticipation of bankruptcy. Now, one thing you really must not do is start incurring new debts in anticipation of bankruptcy. As a matter of fact, the Bankruptcy Code has a provision that prohibits an attorney to counsel a potential bankruptcy debtor to incur debt in anticipation of bankruptcy, especially if it's to pay the attorney's fees. And this was at one point challenged as being a violation of the First Amendment's free speech provision. And this bubbled up to the U.S. Supreme Court, and the Supreme Court said, no, this is not an infringement of free speech, even though the attorney is counseling the debtor to do something that is not technically illegal. But there was an interesting statement in it that was authored by Elena Kagan. She said, this does not mean that an attorney can't have a frank discussion with a client about incurring debt for a non-bankruptcy purpose. And the quintessential example is the car is about ready to die. Well, if you go buy a car and incur that new car loan, that can change the question of eligibility, for example, for Chapter 7 bankruptcy. If you're saying, you really need to do this because that car payment will make it possible for you to be in a Chapter 7, well, that's prohibited. But if you have a different situation where the debtor's car is on its last legs and you say, you really need a reliable car to get to work, why don't you go buy a car? Yeah, you're going to have a new debt, but at least you'll have a way to earn money so that once you're in the bankruptcy, you will be able to make ends meet because you'll still be able to work. That's okay. But as a general rule, we discourage people from incurring new debt in anticipation of bankruptcy. Now, what about the business who has an ongoing relationship with vendors who supply the business with consumer goods that the business turns around and sells in the retail market? Each time a new delivery is deposited at the debtor's place of business, the debtor has incurred a new debt unless this has been paid in advance. Is that okay? Yes, because if it's in the ordinary course of the business's daily life, that's okay. Yet another thing that is really a dangerous thing to do, in fact, I always tell people, not only don't do this, but if you've done it, undo it. And that is something called fraudulent transfer. Now, we talked a little bit about this idea of preferential transfer, or preferences, where you're preferring one creditor above another. Fraudulent transfer is a bit broader, and it goes back to ancient Rome. The ancient Romans had not only a well-developed bankruptcy system, that was developed by Julius Caesar because he had a lot of debt. Probably played a significant role in his assassination on March 15th, 44 BC. They also had a well-developed fraudulent transfer law system. And what is a fraudulent transfer? Well, a fraudulent transfer involves transferring an asset to somebody with the intent to hinder, delay, or defraud that creditor, or without getting a reasonably equivalent value in exchange for the transfer. So let's say you've got creditors coming after you've got this valuable asset, you transfer it to your brother. Fraudulent transfer. If you do that, the creditor outside of bankruptcy has the authority to undo the transfer and seize the asset to the extent necessary to pay the antecedent debt. Inside of bankruptcy, if you're in a chapter that has a trustee, the trustee is empowered to step into the shoes of the creditor and undo the transfer. And in this case, the trustee can undo the entire transfer, even if that's more than is necessary to pay that particular antecedent debt. And if you're filing under Chapter 7 and you've done a fraudulent transfer within the 1 year prior to filing the petition, you are automatically ineligible to get a Chapter 7 discharge. So that is definitely something you don't want to do. And if you do a Chapter 11 and you're the debtor in possession, you're going to face having to undo that fraudulent transfer, whether you like it or not. So fraudulent transfers are bad. And the look-back period is much longer than with preferences. It is 2 years in the Bankruptcy Code's fraudulent transfer provision, but the Bankruptcy Code permits a trustee or a debtor in possession to piggyback on non-bankruptcy law and use the look-back provision in non-bankruptcy law. Under California law, the look-back period is 4 years from the date the transfer could have been readily discovered, and additional time if it couldn't have been readily discovered up to 7 years. And if the IRS is one of your creditors, the trustee can piggyback on the IRS's statute of limitations, which is 10 years. So fraudulent transfers are absolutely terrible. Don't ever think about doing those, but especially on the eve of bankruptcy. And I have had clients who come to me and they've done fraudulent transfers, and I've instructed them, you need to undo those transfers and recover the assets before we file the bankruptcy papers. And there is a Ninth Circuit Court of Appeals case in re Adib. Adib was the debtor's name. And Adib got some abysmal counsel from a bankruptcy attorney and had done some fraudulent transfers and then got better counsel and realized, ooh, I better undo these transfers, and immediately went to work undoing the transfers. And those transfers had taken place within the 1 year prior to filing the bankruptcy petition. So he had undone those transfers and he filed the Chapter 7. The U.S. Trustee's Office took the position he was ineligible to get that discharge. And he appealed, and it went up to the Ninth Circuit. And the Ninth Circuit said this guy was undoing all those transfers. So it was as if he hadn't done the transfers at all. So he is entitled to his discharge. So I've had, for example, clients in the individual context who transferred the house to the kids so that upon death there won't be the tax consequence of inheritance. Well, I tell them, look, you got to undo the transfer, get the house back into your name, go through the bankruptcy. Once it's completed, you can transfer the house back to the kid. But if you don't, the house is on the chopping block. And the worst part of it is you can't even exempt the asset because it's not yours to exempt. So to sum up, some things you absolutely should not do. Don't do preferential transfers. Don't do fraudulent transfers. Be careful on paying debts down so that you can qualify for the Small Business Reorganization Act, or maybe to qualify for Chapter 13 because you have the issues with preferences.